A central inquiry in political science is what sustains the world's largest democracy. The answer, fundamentally, resides within its constitution. This document is not merely a legal framework, it is a foundational text that articulates the nation's ethos. In this analysis, we will conduct a systematic examination of the salient features of the Constitution of India, proceeding from its guiding philosophy to the specific rights and duties it establishes for its citizenry. Our examination will be structured into 6 parts. We will begin with the foundation and guiding philosophy of the Constitution. Following this, we will analyze the nature of the Indian state as defined therein. The third section will detail the structure of the Indian governments. We will then proceed to the rights, duties, and directive principles. The fifth section will cover the mechanisms of constitutional amendment, and finally, we will conclude with a critical analysis and a summary of the key features. Let us begin with the first section, the foundation and guiding philosophy. Here, we will analyze both the physical form of the constitutional document and the spirit which animates it.
The first salient feature to note is the Constitution's form. It is the longest written constitution in the world. At its inception, it contained 395 articles, which were organized into 22 parts and 8 schedules. This considerable length is not arbitrary. The framers were tasked with drafting a comprehensive legal document for a uniquely diverse nation. It was therefore necessary to include detailed provisions for both the Union and the states to avoid ambiguity and ensure a cohesive legal structure.
The preamble serves as the introduction to the Constitution and encapsulates its core philosophy. It is, in essence, a declaration of the document's objectives. The legal scholar J.N. Pandey described it aptly as, quote, the key to open the mind of the makers, end quote. It provides a concise summary of the aims and aspirations the Constitution seeks to realize.
Let us examine the 4 essential components of the preamble. First, it identifies the source of authority, which is vested in we, the people of India, thereby establishing the principle of popular sovereignty. Second, it declares the nature of the Indian state to be a sovereign, socialist, secular, democratic republic. We will define these terms in detail shortly. Third, it specifies the objectives of the Constitution, to secure for all its citizens justice, liberty, equality, and to promote fraternity. And fourth, it states the date of its adoption, the 26th of November, 1949.
It is important to note that the preamble has been amended. The 42nd Amendment Act of 1976 introduced 3 new words: socialist, secular, and integrity. These additions were intended to further clarify and emphasize the guiding principles of the Indian state. The legal status of the preamble was definitively settled in the landmark ruling of Keshavananda Bharati versus the state of Kerala in 1973. The Supreme Court held that the preamble is an integral part of the Constitution. Crucially, this case also established the basic structure doctrine. This doctrine posits that while Parliament has the power to amend the Constitution, it cannot alter its fundamental or foundational features, which are considered its basic structure.
This brings us to our second section, the nature of the state. Having noted the terms used in the preamble, let us now undertake a more detailed analysis of their meaning and implication for the character of the Indian Republic.
Let us define these core characteristics. First, sovereign denotes that India is an independent authority, both internally and externally. It is not subject to the control of any foreign power. Second, the term socialist signifies a commitment to social justice and a mixed economy model, rather than a purely laissez-faire capitalist system. Third, secular establishes that the state has no official religion. As per Articles 25 to 28, it must treat all religions with equal respect. Finally, a democratic republic signifies 2 things: that ultimate power is vested in the people, and that the head of state, the president, is an elected official, not a hereditary monarch.
The Indian conception of secularism is distinct from the Western model. Western secularism is often characterized as negative, implying a strict wall of separation between the state and religion where neither interferes in the affairs of the other. In contrast, Indian secularism is positive. It is based on the principle of Sarva Dharma Sambhava, meaning equal respect for all religions. Under this model, while the state is neutral, it is not entirely separated from religion and can intervene in religious affairs for the purpose of social reform.
The constitutional importance of secularism was further solidified by the Supreme Court in the case of S.R. Bommai versus the Union of India in 1994. In this ruling, the court unequivocally held that, quote, secularism is the basic feature of the Constitution, end quote. This elevated secularism to the status of a non-amendable principle under the basic structure doctrine.
We now proceed to our third section, concerning the structure of Indian governance.
Here, we will examine the institutional framework and the principles of separation of powers as established by the Constitution.
The Constitution establishes a parliamentary system of government based on the British Westminster model. This system is characterized by a distinction between the nominal and the real executive. The president is the nominal or de jure head of state. However, the real executive power, the de facto power, is vested in the Prime Minister and the Council of Ministers. A key feature of this system, articulated in Articles 74 and 75, is the principle of collective responsibility, wherein the executive is accountable to the legislature, specifically the Lok Sabha.
The Indian Constitution provides for a single, integrated judicial system. This structure is hierarchical. At the apex is the Supreme Court of India. Below it are the high courts at the state level. And at the base of the hierarchy is the subordinate judiciary, consisting of district courts and other lower courts. This integrated structure ensures the uniform enforcement of both central and state laws throughout the country.
A defining characteristic of the Indian political structure is that it is a federal system with a strong unitary bias. Often described as quasi-federal, it incorporates features from both systems. Federal features include the existence of a dual polity, the union and the states, a clear division of powers, a written and supreme constitution, and an independent judiciary. However, several unitary or non-federal features are also prominent. These include single citizenship, the appointment of state governors by the central government, the existence of all India services, and powerful emergency provisions under Articles 352, 356, and 360. This creates a unique constitutional arrangement that balances state autonomy with the need for national unity and integrity.
Having examined the structure of the state, we will now turn to the fourth section, Rights, Duties, and Principles. This section addresses the fundamental relationship between the state and the citizen as defined by the Constitution.
The Constitution confers upon citizens both entitlements and obligations. Part 3 of the Constitution enumerates the fundamental rights which are found in Articles 12 through 35. These rights are justiciable, meaning they are legally enforceable by the courts. Article 32, for instance, provides a direct remedy for their enforcement. In contrast, Part 4A, which contains Article 51A, lays out the fundamental duties. These were added by the 42nd Amendment Act of 1976. Unlike fundamental rights, these duties are non-justiciable. They serve as moral obligations for citizens rather than legally binding commands.
This leads us to the concept of the welfare state, which is a key objective of the Constitution. This is pursued through a balance between the fundamental rights in Part 3 and the directive principles of state policy, or DPSPs in Part 4. While rights protect the individual, the directive principles guide the state towards achieving broader socioeconomic goals. The Supreme Court, in the case of Minerva Mills versus the Union of India in 1980, affirmed that the harmony and balance between fundamental rights and directive principles is an essential feature of the Constitution's basic structure. One cannot be sacrificed for the other.
A constitution must be a dynamic document, capable of evolving with the times. Our fifth section, therefore, examines the mechanisms of change, focusing on the procedures for amendment and the provisions for citizen participation.
The Indian Constitution strikes a balance between rigidity and flexibility. This is reflected in its amendment process, primarily governed by Article 368. There are 3 methods of amendment. First, certain provisions can be amended by a simple majority of Parliament, similar to the process for ordinary legislation. Second, most provisions require special majority, that is, a majority of the total membership of each House and a majority of 2/3 of the members present and voting. Third, for provisions affecting the federal structure, an amendment requires not only a special majority, but also ratification by the legislatures of at least half of the states. This synthesis of rigidity and flexibility is a notable feature.
Citizen participation is primarily ensured through the principle of universal adult suffrage. Article 326 of the Constitution grants the right to vote to every adult citizen without discrimination. A significant amendment in this regard was the 61st Amendment Act of 1988, which reduced the constitutionally mandated voting age from 21 years to 18 years, thereby expanding the democratic base of the nation.
We have now reached our final section, analysis and summary. In this part, we will conduct a brief critical evaluation of the Constitution and then consolidate the salient features we have discussed. While the Constitution is widely lauded, it is not without its critics. 4 primary limitations are often cited. First, its sheer bulk and complexity are said to contribute to excessive litigation. Second, it has been described as a bag of borrowings for drawing heavily from the constitutions of other nations. Third, the pronounced unitary bias is seen by some as a potential threat to state autonomy. And fourth, the non-justiciable nature of the directive principles of state policy means that their implementation is left to governmental discretion, which critics argue renders them mere declarations of intent.
In summary, we can consolidate the salient features of the Indian Constitution as follows. It is the world's longest written constitution. Its preamble declares India to be a sovereign, socialist, secular, democratic republic. It establishes a parliamentary system of government. It provides for a unique blend of rigidity and flexibility in its amendment process under Article 368. It guarantees justiciable fundamental rights while laying down non-justiciable directive principles to achieve the ideal of a welfare state. It establishes an independent judiciary with the power of judicial review. And finally, it provides for single citizenship and a universal adult franchise. These features collectively form the framework of a living constitution that has guided the Indian Republic for over 7 decades.